What you see here is a cedar tree that is more than likely 500 to 800 years old. This is where you could get 40, 45-foot canoes made with the right cedar, choosing the right cedar. And then on the other side of this tree, you can see how the Huu-ay-aht people utilize this tree. You can tell it's a culturally modified tree. It has been used by our people probably hundreds of years ago based on the scar that's on the other side. They used to gather cedar. We call it a cedar tree, Huu-ay-aht. And the bark, when they call it, we call it pitsup. And we use it for many things. Cedar was very, very valuable. You can't even put a dollar value on that, eh? And that's the unfortunate part, is that in a specific claim, you can't put a cultural value. Like it's priceless, what a cedar meant to the Huu-ay-aht people.
The Huu-ay-aht and these forests on Vancouver Island are at the center of a groundbreaking legal decision, one that could put billions of dollars on the table for First Nations across Canada. Along this well-kept logging road south of Port Alberni is the Namukamas 1 Reserve. In 1938, the Huu-ay-aht surrendered the logging rights here to the Government of Canada in trust. The idea was that Canada would then tender those rights to a logging company. And within 5 years, there would be forestry jobs and logging money for the Huu-ay-aht. That didn't happen.
The land was surrendered. There was no logging done for years and years and years. So in other words, the one that got the forest arrangement, was able to hold on to it until the market improved to where they were satisfied to when they could log with no benefit to us.
Chief Councillor Robert Dennis has been part of the Huu-ay-aht leadership for decades. For most of that time, he's been working on the Huu-ay-aht specific claim, a special legal process through which First Nations can be compensated for certain types of damage Canada has done to them.
Our forefathers, took a step thinking that, they could be looked better after, much better if they surrendered the land. And as they found out, surrendering the land was not a good thing.
Canada gave the Namukamas logging rights to a company called BSW Limited, and they didn't use the usual tendering process. BSW didn't start logging until 1948. The Huu-ay-aht lost out on a decade of logging profits and job income, at a time when demand for BC lumber was at its highest. Canada had breached its fiduciary duty to the Huu-ay-aht. So they began the process that would later come to be known as a specific claim.
This was a claim that went to the tribunal on the basis of inability to negotiate a settlement. There was just no middle ground that could be found.
Robert Groves is often hired by First Nations to negotiate specific claims on their behalf. He did not work on the Huu-ay-aht claim, but he has spent decades working on other claims across Canada.
Originally, the specific claims policy back in 1973, when it was developed under another Trudeau, the elder, was extremely fact-based. So if you could show damage through diligent due research, that was great. You do that, okay? And then start negotiating. But as court decisions started to mount, and wherever the federal government won a decision, it would take that little win and then apply it everywhere, right? And so all of a sudden, even though your fact situation, let's say as part of the Manaulth First Nation, is totally different than the situation faced in Whitefish River, for example, all of a sudden you're having that rule applied to you.
You see, when Canada sits down at the negotiating table, they don't start by asking, well, what's fair? First, they'll look at the hundreds of specific claim decisions in the past, and they'll pick and choose the ones that are the most favorable for Canada. In this instance, favorable for Canada means quick, easy-to-apply formulas that can be used anywhere, and thus rarely deal with the actual facts of any given case. Then they'll sit down. and their starting position will be something like, well, such and such a precedent exists, why don't we just follow the letter of the law and do what has already been done? The problem for First Nations is that these quick formulas and precedents are often built on Eurocentric principles of economics. They often make sweeping Eurocentric assumptions about how finances work. A perfect example, perhaps the broadest and most influential example, is called the Pareto principle.
Italian mathematician Vilfredo Pareto came up with it when he saw that 80% of the peas in his garden came from 20% of the pods. Then he saw that 80% of the land in Italy was controlled by 20% of the citizens, the wealthiest 20%. He studied other countries and saw the same thing there. In fact, wherever Pareto looked, he could see examples of that same 80-20 distribution. In the 1950s, insurance agents in North America started applying Pareto's 80-20 rule to matters of compensation for losses. They said, on average, a person consumes 80% of their wealth and only saves 20%. So they'd only give compound interest on 20% of what you've lost. Ottawa adopted this as their standard for paying back First Nations in specific claims.
The insurance industry, and therefore the department, because it was kind of neat and it was precedent, even though nothing to do with First Nations. They adopted the 80-20 because it sounded easy, right? 80% gone.
We weren't just blowing our money. We weren't just spending money. And that was Canada's argument, that we were consuming the money anyway and we were just wasting it and not spending it well, not spending it prudently.
But there's a catch. They were spending it prudently, and by Indian Affairs' own rules.
Well, as several court cases, including the one we're dealing with here, said, well, wait a minute now. The money would have gone, if they'd gotten the money into their trust account back then in the 20s, starting in the 20s, only 10% would have been consumed. 90% would have gone into an interest-bearing account, because that's the way the department ran things then with regard to capital monies accounts or revenue money accounts.
That's right. Back in the day, Indian Affairs would force the Huu-ay-aht and other nations to put 90% of monies like this into a trust fund partially governed by Indian Affairs. But if Ottawa caused a breach with those monies, they'd only pay back 20% at the proper compound rate.
Now, there's a case to be made that this was simply the left hand not knowing what the right hand was doing, that this was unintentional. But whether or not it was intentional, it was certainly profitable for Ottawa. Canada would go on to use Pareto's 80-20 model, as well as a number of other broad, sweeping economic models, for many years in specific claims, until the Huu-ay-aht decision in 2016. In this decision, Judge W.L. Whalen made an unprecedented move. He rejected the economic model put forward by Ottawa and accepted the model put forward by the Huu-ay-aht. That model, the Huu-ay-aht's model, was developed by a University of Toronto economics professor named Arthur Hosios.
The problem with the 80-20 model is you can't say there's no evidence. It says that every band that I apply that model to, 80 cents on the dollar is consumed, 20 cents is saved. Well, that has nothing to do with any particular band. It's entirely made up by the government. And so I think the key for me is to identify data which really specializes the version of my model to a particular band's experience.
Hosios' model throws out Pareto's 80-20 rule. It looks at the band's actual spending with the money it did have, and applies that behavior to money the band could have received had it not been the victim of a breach. All of that money, whether it was consumed or saved.
So the idea is that I observe the actual spending behavior of the band, at least the collective, right? And from that, and the incomes that this other expert provided to me, I put those together and create this history of spending.
The compensation under Hosios' model was significantly higher. Under the Crown's model, the band would have gotten just over $2.9 million in compensation for the lost investments alone. Under Hosios' model, the band received approximately $14.5 million when compensated for both lost consumption and investments. The compensation under Huu-ay-aht's model was 5 times greater as a result of compensating for consumption. Imagine every specific claim in Canada being 5 times bigger. That's the money that's at stake.
If you take that level of variance and apply it to something the size of the Haldimand Tract and Six Nations, like, we're talking into the billions of trillions of dollars, aren't we?
Certainly billions. I'm not sure trillions, but it depends on, again, the lost opportunity. Professor Huu-ay-aht, he looked as well at the specific investment and expenditure patterns, whereas I think the experts for the Crown, they took a much more of a cookie-cutter approach and making grand assumptions about what might have happened without looking at the actual fact situation. And I think the judge says, well, that's just all speculation. And you can't, equitable compensation cannot engage in speculation, right? It has to be rooted in reality.
Canada has put forward many different models. It's a moving target. They'll try, anything that works. If you look at the data, the difference between compounding interest rates and inflation over a 100-year period is truly significant. In other models that the Crown has put forward, they value consumption at 0. In fact, in Huu-ay-aht, that the expert on the other side made that argument, and the judge rejected that.
What we're seeing here is what we commonly refer to as heart of the people. This valley, this place, it's priceless. It means everything to us. You cannot put a value what this valley means to the Huu-ay-aht people. So that's why when we start talking about negotiating, what does it mean? Well, you can't put a value on cultural value. It's just priceless. So if we wanted to, like I could easily say this is worth $1 billion to us, But then you look at a businessman and say, oh, well, the timber is only worth, 200 million. So that's the kind of discussions that we get into.
How much of this, of what we can see from here, is the land covered by the Namukamas specific claim?
You would virtually be looking at all of this. What you see in here is the Namukamas claim, and you can see where they're logging now. That's second growth. So that means that whole hillside was clear-cutted. There was no consideration to what would happen if you clear-cut that hillside. And so what happened was that all the debris and the rock went into the river. And if I were to take you down into the estuary of the Sarita River, you would see stumps, you would see logs that have come down from the mountains and ended up in the river estuary. It's devastating.
When you look at the land like this, it's tough to imagine it being 3 million or even 14.5. For seconds worth a lot more.
Oh, it is, and that's what I'm saying. You can't put the value to what was this valley worth to the Huu-ay-aht before it was even touched. And in terms of today's dollars, 14 million doesn't do it justice. It values the timber that was removed, but it doesn't value, that the salmon stream was destroyed. We made a living with fishing salmon, and now we can't. There was one time that Huu-ay-aht had dozens and dozens and dozens of licensed boats, and I think now today we're left with 5 or 6. So that's the devastation that's happened.
This is what happens when Canada breaches its fiduciary duty to a First Nation. Lost homes and livelihoods, ways of life, the heart of the people. This is what the specific claims process is supposed to help restore. And with Judge Whalen's decision in the Huu-ay-aht claim, it has a much better shot of doing that than it used to.
I look at it as our forefathers were very, very prudent, very, very smart to make a petition to say that Indian Affairs wasn't managing our license properly. And they said, we feel we are not going to realize for ourselves and our heirs the fullest benefits to which we are rightfully entitled to. I think that was really smart for our forefathers to say that. So here we are, we have a ruling.
The Huu-ay-aht received over $14.5 million after Whelan's decision. Here at the annual People's Assembly, they'll decide what to do with it.
My personal view is that, if we're going to go into a big project, that we use that money for that project, because you don't have anything earmarked for it right now. The reason I say that is I don't want to, if you're into a big project, I don't want to saddle our future generations with it, no matter who we are.
Thank you, Yatlu. I really appreciate your comments, and I concur that there should be some kind of process that we look at what we want to do with it. What we'll be doing next is to engage with the community, let them know about the specific claim, because there's some people that don't attend the meeting. So this will give people an opportunity for more of our people to hear what happened, and then also to engage with them to say, what are some of the projects or initiatives that we could undertake.
After Whelan's earth-shaking decision, Chief Councillor Dennis has some tough decisions ahead about how to spend the money. But there are still repercussions happening around the country. In Ottawa, the federal government has chosen not to appeal the decision. In a joint statement, Ministers Carolyn Bennett and Jody Wilson-Raybould said, on September 5th, Canada withdrew its application for a judicial review of a specific claims tribunal decision in Attorney General of Canada versus Huu-ay-aht First Nation. This decision was made based on particular factors and circumstances specific to this particular case. The Huu-ay-aht Nation has waited far too long for the Government of Canada to make amends for past wrongs. And while we disagree with the formula to award compensation determined by the tribunal, the government has taken this decision in the interest of moving past this case and advancing reconciliation. Minister Bennett declined an interview for this story and instead referred us again to the above statement. Withdrawing an appeal is highly unusual. Canada typically fights such decisions all the way to the Supreme Court. Robert Groves thinks it's a tactical choice.
Well, I think the decision by Justice Whelan dealt a firm blow to the economic theories that had favored the Crown in earlier rulings and in all their negotiation approaches. They've saved themselves a precedent by not appealing.
I was going to bring that up because if Huu-ay-aht goes to higher courts, then it becomes more and more legally binding.
Yeah, Huu-ay-aht right now, the decision that Whelan has provided is limited to Huu-ay-aht. Possibly limited, possibly becomes a good solid precedent for similar fact situations like involving trust accounts and monetary losses because of misadministration, maladministration. But if it went to appeal and was upheld, then it becomes binding, right, for a broader range of settlements. And if it's appealed again, and it goes up to eventually the Supreme Court, and the court comes down and sets, and they endorse Whelan, it's mandatory on all fronts for all claims. And the federal government negotiation ability is really now restricted. They cannot play the 80-20 rule. They can't play the simple versus compound interest game, and so on and so forth.
So I read the statement by the ministers, and in which they chose not to, argue the appeal, but made an explicit statement, as you suggested, that the methodology, that they don't accept the methodology employed. And I asked a bunch of lawyers what they thought the strategy was. I think anybody's guess now. I think that they were concerned that if they go to the next level and their argument doesn't work, then they're really in trouble.
Hosio says his model can be used in other specific claims as long as you have the right data, and that there's more reasons to do so than just equitable compensation.
Now, from an economic perspective, why does a party breach a relationship? In other words, violate the terms of a contract. Well, if the benefit to me of violating a contract exceeds the cost, I'm in. Not to be too economic about this. But that's the exact same argument with this fiduciary story, which is that Canada, if it perceives the cost of breaching its duty to the band as being very small, in 1900 I save a lot of money, I pay out very little in 2017. The argument here is not that I'm accusing Canada of intentionally breaching its relationship in certain circumstances. It may have, it may not have. But the incentive there is to do so. You'd have to provide some compensation for consumption to make the cost to the breaching party sufficient to encourage it not to engage in that breach.
In other words, making specific claims more expensive helps to deter damages in the future. Huu-ay-aht stresses, though, that his work is unbiased.
Now, I have to say that if I were hired by the Crown, I'd give the identical testimony, because I think the model's right. It's as simple as that.
Groves wonders about all the closed specific claims in the past. Now that Huu-ay-aht's model is a precedent, can they be opened back up?
If, in all fairness, a new court-mandated model emerges to apply to this and similar cases, and I think in most cases are going to find similarities. It is possible, I suppose, for someone to argue that there was no fairness in the final agreement, and they were effectively browbeat into it. But that's a real tough argument to make. But if the federal government wishes to reopen these things, it can certainly do it.
Next week on APTN Investigates.
It's a cultural genocide that's happening in Labrador because of the actions of this project.
The controversial hydro project at Muskrat Falls has sparked fear, protests, outrage.
This was a story that had to be told.
Dozens of people face charges.
It's going to wipe out my traditional food as an Inuit person. And for me to be told that I can't protest that, that is injustice.
The colonial legal system says to me that my way of life is illegal.
But we're dealing with a corporation that has singled out a journalist, is targeting a journalist.
You hurt me!
Many Innu and Inuit say reconciliation and sunny ways are nowhere to be seen in the shadow of the dam.
If there was reconciliation, I wouldn't have gone to prison.